Hello all. Today we are going to go through legal research certification as a makeup for those of you who weren't able to join us for the in-class sessions that we had on campus. Of course, my name is Heather Caro and I'm your Lexis rep, but so as not to recreate the wheel, I'm actually going to be using a video that a good friend of mine put together. She is the Lexis rep for Vanderbilt and UT. So this certification process is a two-step process. First, you must watch the video and then email me for a quiz link. And as mentioned in the email that you already received, you'll receive some points for watching the video and also 400 points for successfully passing the quiz. So be sure that you read the hypo before watching this video that I've included in the email so you're up to speed and you know exactly where these searches are coming from. One other thing to note is once you've successfully passed the quiz, within 14 days, your name will be added to the National Registry of Certified Students, which you could then direct your employers to show that you are indeed certified. And it's also something that you can add to your resume and your LinkedIn profile. And so without further ado, I give you Bianca White, who will be going through the legal research certification training with you guys.
All right, here we go. So as noted in our prompt, we are going to start with the case that the assigning partner has given us, and he thinks that's going to be the binding authority. We need to verify that it's in fact still good law. So we're going to start by entering our search terms or title of the source here in the red search box. If we have the citation for the case, we would enter that. But since we don't, we're going to go ahead and start entering by the title name of the case. And Tinker is the title name, and we see it actually pre-populates up there in the word wheel. So then we can just click that name and then run the search by clicking the search button. And that's going to take us directly to the Tinker opinion. Once we're actually in the opinion, there's a couple of things that we want to look at. If you scroll down to the case summary, you have a nice little overview of what this case is about. And that's really important because it gives you some context before you dive into the case and really start reading all of the opinion. Under that, you have the head notes, or the points of law of the case. And these points of law are really important because it's the propositions that this case stands for. Even more important than that, however, is that it's the exact language of the case. So we see here that head note 1, the wearing of symbols like armbands cannot be prohibited unless it is materially and substantially, so on and so forth. So this is the point of law. We can use the drop down to take us directly to the portion of the opinion where that point of law is established. If we jump back up to the top, it's going to take us back into those head notes and provide that topical breakdown of what each of those points of law represent. Now, all of this is created by Lexis editors. So this is an editorialization created by editors. The head notes are the actual language point of laws pulled up to the top by editors. The breakdown of topics is created by editors. But we can go to the actual portion of the opinion by using this Jump To button. The Jump To button is going to give you a bunch of different options for different parts of the opinion to go to. And to actually get to the official language where the opinion would start in the reporter, you'll come over here and select Counsel. And that's going to provide you the counsel of records for this case, the judges that sat on this case, an opinion by Fortis is letting you know that Judge Fortis is the one that actually authored the opinion. And this may or may not be the answer to one of the questions on the quiz. All right, so now we've reviewed the case. We see that it is in fact relevant. The next thing that we want to do, as per the assigning partner, and what we always want to do when we have authority, is shepherdize it to verify that it is still good law. We can quickly see by looking at the shepherd signal right here that some aspect of this authority has been questioned. There's a little overview on the right, or shepherd's preview, that gives you a breakdown of what the shepherd's report is going to say, and we see that one opinion has actually questioned Tinker. So we can click the symbol to generate the shepherd's report. Shepherd's report's effectively a culling together of all the sources that cite back to the underlying opinion that we have shepherdized. The first tab is the Appellate History tab. This is how this case worked its way through the system. You see the symbol or the citation that we entered. Everything above that is earlier reiterations of this opinion. If there was anything below it, that would show history that came after the citation we entered. So what else happened in this line of the decision? For validation purposes, though, when we're running a Shepard's report, we want to go to the tab where the Shepard signal appears. The Shepard signal appears next to citing decisions, which lets us know that that's where that problematic analysis is created. By clicking this, we get a listing of all of the citations, all of the cases that cite back to Tinker. We see that it's 2,222, so quite a few. But for validation purposes, we don't care about all of those cases. We only care about those cases that cause potentially negative problems for us. And if we look right here under narrow by, you see a breakdown of the analysis. One case has questioned Tinker. 187 cases have distinguished it, and 4 cases have criticized it. Now, just because an opinion has questioned or criticized Tinker doesn't mean it's overturned and we can't rely upon that opinion. What it means is that we have to really kind of investigate and see the problem. And the really only thing we're going to focus in on is questioned. Caution, or kind of this yellow analysis, which is cautionary analysis, is usually one of these scenarios. Distinguished by, that basically just means the opinion says, you know what? Tinker is different than us, from us, so that's why it's not the same. We're different, therefore we don't have to apply the same law. Criticized is just a court saying, you know, we're not overruling it, but we're just not so sure that that's correct. Depending upon which courts these are, it may or may not matter. If it's a higher court that is binding on you, so let's say we're in Tennessee District Court, something the Sixth Circuit Court of Appeals says obviously does matter because they're binding on us in a higher court. But if the Fourth Circuit criticizes us, we probably don't care as much because we're here in the Sixth Circuit because we're in Tennessee. Distinguished is just that. It's unless your factual scenario is more like the distinguished case than the case you're Shepardizing, then you're okay. So don't worry too much about distinguished unless your facts are more like the distinguished opinion than the underlying opinion you're trying to rely upon. So we'll go ahead, narrow down, and focus on questioned opinions only. Once we're here, we see that Herbert PDC is the case that has questioned our opinion. We can click into the top of the opinion, or we can click directly into the portion of the case that has questioned Tinker. And by doing that, it's going to take us right to where Tinker is discussed. And this seems kind of archaic, but what we have to do is we have to simply read every part of this opinion that talks about Tinker to see exactly what it says about Tinker. So this is saying, you know, the material and substantial disruption test from Tinker, blah, blah, blah. The Garland Court stated that the Tinker test applied to speech restrictions on school insiders as opposed to outsiders like unions. So this is showing us that there is a distinction between insiders and outsiders. If we are trying to rely upon Tinker for insiders, which is what our factual scenario is, we know that that question analysis is probably not a big deal for us. But to verify that, what we would need to do is use our jump to, go to references here, and actually go to every portion of this opinion that talks about Tinker to make sure that some aspect of it, in addition to that first questioning, isn't questioned. So just go through there, read through there, make sure that the proposition that you're attempting to rely upon Tinker for hasn't in fact been overruled or questioned. All right, the last tab that we would take a look at is, and we'll back to the Shepard's report to show you, is other citing sources. And this other citing sources is basically everything else in addition to case law that is cited back to the opinion. So you have law reviews, court documents, treatises, statutes, annotations. We can narrow down to which category that we would like, and then use search within results to fine-tune that search as well. Using that will allow you to say, you know, free speech or whatever to cull down those results looking for your specific factual scenario or title, whatever it is you're searching for. All right, and now that we have Shepardized the underlying authority, the next thing we're going to do is just start running kind of an overall search on this particular case. And we're going to start with natural language because that's the default on Lexis Advance, and it's also the easiest way to start when you have a pretty basic topic that you're trying to build some familiarity and understanding with. So we're going to say Internet Student Speech and run the search. And because the legal research process always tells us to start in secondary sources first, that's where we're going to jump to. So we're going to come over here and take a look at secondary sources. From here, we want to narrow down even further. And we're going to come and say, let's look at treatises first. Treatises are those great secondary sources that are basically like an encyclopedia on a topic of law. So this is going to provide us some nice black letter law framing the context of this research assignment. Now, one other quick hack you can do is come over here and take a look at your sources. And the sources is going to be a breakdown of what this results list to the right is made up of. And we see really quickly that there are 38 entries for our search results or our search terms in WRAP education law. We're going to go ahead and select that because that's right on, right? That's exactly the area of law we're looking at, education, specifically internet student speech. So we'll go ahead and grab these results and take a look at what we have here. A nice little listing. You get a breakdown of the title, the chapter. You can segue directly into any portion of the opinion, or you can simply click at the top. Remember, this is sorted by relevance, so the most relevant based on the search terms you've entered should pre-populate up to the top. We'll go ahead and open that source. And once it takes us there, our terms are going to be bolded here. The most important thing to know about these secondary sources are that they're not the law, but they lead you to the law. So it's a lovely explanation of kind of the black letter law with using the footnotes, these little green arrows, to take you down there, which lead you to that nice primary authority. Alrighty, the next thing then that we are going to do is back to our results list. We're going to clear all those tabs that we've already put there, so just press clear to get rid of them all. And then we're going to apply a couple of different tabs. Let's do law reviews and journals. And we're going to fine-tune our results by using the search within results here. And what we're going to say here is student cyber speech. And that's going to tweak that algorithm, that relevance algorithm, focusing with our new terms and incorporating those new terms as well. And once we're here, we can scroll down a little further and come down to jurisdiction. So if we have a very specific jurisdiction we're looking at, that'll narrow it down. Or we can go once again to sources and take a look at all of the sources that are made up of this results list as well. Jurisdiction or sources, whichever you prefer. You see here, South Carolina lawyer. If we're in South Carolina and there's an article in the South Carolina lawyer meeting all of our parameters, that's probably going to be our best bet, because not only does that cover all of those search terms we've entered, but it's even jurisdictionally specific. So it's going to hit not only those constitutional issues, but any specific South Carolina issues as well. So it would behoove us to come and take a look at this particular case. All right, now let's go ahead and we're going to go back up to the top and start this search all over. So we click this Lexis Advanced Research button, and we're going to tweak our search and make it a terms and connector search. So we'll go internet/5, and we're going to put parentheses around student speech. So we're saying we want to find any time internet is within 5 words of student speech. We can see we have a lot less results here, but that's what we wanted. We wanted something more specific. We'll come over to cases and start taking a look at our primary law. Again, remember the relevance algorithm is at play here, so we can go ahead and just open up that second opinion. And when we're waiting to pull it up, I'm going to take a short pause to make sure that my video is loading, and we will do the second video in 2 seconds. All right, hello all, I'm back, and we have just opened the second case in our results list, and we are going to take a look at Evans. Now, we've highlighted a couple of the important parts of all of the cases in the case summary, but something else to note in the case summary, which may or may not be a question on the quiz, is you'll oftentimes find both in the procedural posture and in the overview the claims that were brought in this litigation. So you can quickly see exactly what claims make up this particular litigation to help ascertain its relevance. The next thing that we're going to look at in this opinion are some helpful tools and resources. So if we scroll down here, we can see that we have the headnotes, and that's all good and well. And let's say we find a headnote that's right on point. A mere desire to avoid discomfort or unpleasantness will not suffice. The government may not prohibit student speech based solely upon blah, 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 blah. Let's say that's spot on. Well, what we can do with this single headnote, if that's a point of law that we absolutely want to rely upon and expand our authority, we can click Shepherd-Eyes, narrow by this headnote. And what that's going to do is create a Shepherd's report specifically for this point of law. So all of those cases that have cited back to this opinion for this point of law. Another thing we can do from the headnotes, though, are use the topical breakdown to generate additional searches for us without us having to run those searches ourselves. So anytime you see one of these drop downs, you can simply click that, get documents, and it will effectively generate a brand new search based on the terms of the headnote. So it's taking that headnote and creating a search of relevant sources based on that language. Then, of course, you cull through it like you would any other search results as well. Now let's back on out to Evans, and we are going to Shepherdize it. Let's say this is exactly on point. We want to take a look at this case as well, and let's Shepherdize Evans. Okay. We've already talked about the Citing Decisions tab. We've already talked about other citing sources. The last tab that we're going to take a look at is the Table of Authorities. And the Table of Authorities is so important because it's a breakdown of all of the cases in the underlying opinion. So all of the cases that are listed in Evans are here. You've got two things you want to look at. The first is the Shepherd signal next to each case. And the reason that's important is, in the world of precedential value and stare decisis, your opinion is only as good as the law it relies upon. So if some of the underlying analysis for your case has been overruled or has been questioned or is kind of weak, it's a good idea to go ahead and take a look at that and figure that out on the front end. The second thing you want to look at are these little blue or yellow or whatever color it is squares. That lets you know the treatment that Evans had of each of these particular opinions. And the treatment, you can find a legend down at the bottom that tells you exactly what the Shepherd signals mean, as well as what the analysis bars or colors mean, and the depth of discussion that the case had on each of these opinions. And it's kind of like a stop sign. So for Shepherds or for any of these analysis here in the Table of Authority, red means problematic, yellow means caution, green or blue means go right ahead, no worries. Alrighty, and we are actually almost done. The very last thing that we are going to take a look at is the history. So if we come over here to history, you can see the last 5 searches, the last 5 documents, or the last 5 Shepherd's reports that you've run. You can also come over here and click View All History, which will take you to your last 90 days of history. Now, this is important for a couple of reasons. Number one, your history will be saved for 90 days. So anything you've done in the last 90 days is going to be listed here in your history. So let's say you've done a lot of case law research and you know you found a really good opinion about blah, 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 but you can't remember the name of it. You don't remember even what search terms you used to generate it. You can narrow by date if you have an idea of when that was. You can enter some search terms you remembered reading in the case. Whatever it is, enter it here and it will search all of your history looking for that. As a practical matter, in the real world, when Lexis costs money, anything you access from your history is free. So you basically have 90-day storage to re-access anything without incurring any additional charges. Now, a nice little caveat is, back in the day, in the summer, you lost your academic access to all of the research systems. However, the past couple of years, Lexis has kept your access open in the summer, so you don't actually have to worry about, you don't have too much concerns about being cost efficient this summer because you're going to have access to Lexis for free. So even if you're at a Westlaw firm, you can still use your Lexis ID. Alrighty, and the very last thing, and this is only on some of the quiz, is this research map. So you can click it from the list view over to the research map view. And this creates basically a graphical overview of your research. You can see the search you ran, the results it generated. You can even look and see what cases it was that you took a look at. The next thing you can do is you can compare two different search terms. So you could take your searches from the terms and connectors in the natural language, click compare results, and it will generate a Venn diagram of basic common sources, outlier sources that resulted between those two searches. I don't exactly know the utility of that, but it's a question on the quiz. One thing that is kind of neat is find similar documents. So let's say you found a really good case on there. You can use that case to find similar documents based on something that was fairly good that you got. Alrighty, well, thank you so much for joining me. Again, I cannot apologize enough for having to use this format and canceling last minute. I'm going to include your names in the raffle for Fridays as well, and we'll just draw a couple of extras to make sure that you are in fact still included in the raffles. Feel free to join us on Friday for Shepherd's Training. Let me know when you have finished this last video, and I will shoot you the quiz. Good luck. Thanks so much.